Welcome to the Deep Dive, where we cut through the complexity and extract the most important nuggets of knowledge from a stack of sources. Today, we're diving into something that touches every single aspect of our lives, often without us even realizing it: the law of the United States. Our mission today is to uncover its fascinating structure and the surprising variations that truly define American legal systems. Our source material is a comprehensive overview, providing a direct route to being well informed on this fundamental topic.
Indeed. It's fascinating how pervasive the law truly is. I mean, from the major constitutional principles that shape our nation to even the most everyday details, like, the regulations on a parking sign. Our goal here isn't just to tell you what the law is, but, well, to help you understand why it operates the way it does and how it impacts you directly.
Okay, let's unpack this. So at a general level, the law of the United States, it comprises many levels of both written or codified and unwritten forms of law. And at the very top, the supreme law of the land is the nation's constitution.
That's the foundation.
Right. This constitution prescribes the foundation of the federal government and various civil liberties. It also sets the boundaries of federal law, which includes acts of Congress, treaties ratified by the Senate, regulations issued by the executive branch, and case law originating from the federal judiciary. And for those wondering, the United States Code is the official compilation of all this general and permanent federal statutory law.
And what's really fascinating here is that the U.S. operates under a dual sovereign system of American federalism, which means both the federal and state governments have their own distinct and, well, powerful authorities.
Sovereign, okay.
Yeah, and while there are unique legal considerations for Indian reservations that add another layer, the key takeaway for most citizens is this powerful federal-state divide. States are considered the plenary sovereigns, meaning they hold broad, inherent authority.
Plenary, meaning like full or complete.
Pretty much, yeah. Broad, inherent power. The federal government, by contrast, possesses only the limited supreme authority that's specifically spelled out, enumerated in the Constitution. So this means states can actually grant their citizens broader rights than those found in the federal Constitution, as long as they don't infringe upon federal rights.
That's crucial, isn't it? Because it means the very fabric of your daily legal interactions, from buying a house to, I don't know, getting married,
Yeah,
can fundamentally change just by crossing state lines. It's a truly decentralized system.
absolutely. And that's a core insight into how American law operates.
So much of the actual living law that you experience, daily things like contract law, tort law, property, criminal family law, consists primarily of state law.
That's right.
And this, importantly, can and does vary greatly from one state to the next.
Hugely. Even in areas where federal law exists, state law is often supplemented rather than fully replaced or preempted.
Ah, so they work together sometimes.
Exactly. Even when the federal government steps in, states often have their own complementary rules. It's not always an either situation.
Okay, so we've mapped out these foundational levels, federal and state. But where does all this legal authority actually come from? Let's break down the 5 core sources that feed into this system: constitutional law, statutory law, treaties, administrative regulations, and what we call the common law, which includes case law.
Right. And let's maybe start with constitutionality. It's a big concept. If Congress enacts a statute that conflicts with the Constitution, state or federal courts have the power to rule that law unconstitutional and declare it invalid.
Okay, the courts can straight down laws.
Yes, this principle was famously established way back in Marbury Madison in 1803. But here's an interesting detail. A statute doesn't automatically disappear or get, wiped off the books just because it's been found unconstitutional. It might remain there for decades.
Wait, really? That's a fascinating nuance. So the law is invalid, but it's still there.
It can be, yeah. The insight here is that legal change isn't always instant or clean. A law might be ruled invalid, but its ghost can linger, potentially causing confusion or requiring further action to fully remove it. It speaks to the sometimes slow and deliberate pace of our legal machinery.
So how does that work in practice then?
Well, under the principle of stare decisis, that means to stand by things decided, a lower court that tries to enforce a statute previously declared unconstitutional risks being reversed by the Supreme Court.
Ah, okay.
And conversely, a court that refuses to enforce a statute previously upheld by higher courts also risks reversal. So while it stays on the books, any court trying to apply it would be immediately challenged based on that precedent.
Got it. That principle of judicial review is powerful, but it makes you wonder, where did these courts get such authority in the first place? To understand that, we need to trace the roots of American common law, right?
Exactly. The United States, along with most Commonwealth countries, inherited the common law legal tradition from English law, which was the law enforced during the American Revolutionary War.
Okay, so we got it from England?
Largely, yes. But it's worth noting that certain practices traditionally allowed under English common law were expressly outlawed by the U.S. Constitution,
Right.
things like bills of attainder and general search warrants. The founders wanted to prevent specific abuses.
Right. Checks and balances.
And as common law courts, U.S. courts inherited stare decisis, that principle we just mentioned. This means that American judges, much like their common law counterparts elsewhere, don't just apply the law. They also effectively make the law through their decisions, which then become precedent for future cases.
So judges make law too, not just legislatures.
In a sense, yes, through interpretation and precedent. Now, English law was formally received into the U.S. system in a couple of ways. First, nearly all U.S. states, with the exception of Louisiana, which has a civil law tradition enacted reception statutes.
Reception statute.
Yeah, these generally stated that the common law of England, especially judge-made law, was the law of the state, provided it didn't go against local laws or unique state circumstances. Sometimes they set specific cutoff dates, like adopting English law as it existed in 1776. Second, a small number of important British statutes that were in effect at the time of the Revolution, such as the Statute of Frauds, were independently reenacted by states and are still regularly cited today.
But here's a surprising twist I read about. Despite these reception statutes, contemporary American common law has diverged significantly from English common law. Is that right?
Oh, absolutely. Massively. American courts today rarely follow post-revolution precedents from England or the British Commonwealth.
Why is that? Why the split?
Well, historically, early American courts, even after the Revolution, often did cite contemporary English cases. That's mainly because appellate decisions from many American courts weren't regularly reported until the mid-19th century. So English legal materials kind of filled that gap.
Ah, practicality.
Exactly. Yeah. But citations to English decisions gradually disappeared during the 19th century as American courts developed their own principles to resolve the legal problems of the American people. This led to an explosion of American reports. I mean, from just 18 volumes in 1810 to over 8,000 by 1910.
Wow, 8,000 volumes.
Yeah. By 1879, one delegate to the California Constitutional Convention was already complaining about the sheer volume of fine judicial literature being produced. They were creating their own distinct body of law.
That makes sense, building their own system.
Right. And Lawrence M. Friedman, a Stanford law professor, reinforces this divergence. He states that American cases rarely cite foreign materials, end quote. He notes that courts might occasionally cite a British classic or an old famous case or give a nod to foundational thinkers like Blackstone. But current British law almost never gets any mention. When foreign law is cited, it's typically just as a reflection of shared values or maybe persuasive reasoning, not as binding precedent.
Okay, so American law really became its own thing. What does all this mean for you, the listener, and how the law impacts your daily life? We've talked about the federal-state divide. Now let's dive into the different levels, maybe starting with federal law again.
Sure.
Federal law originates with the Constitution, which gives Congress the power to enact statutes for certain limited purposes, like regulating interstate commerce. And we mentioned the United States Code is the official compilation of these statutes.
Correct. And federal statutes are created through a specific process. After a bill becomes law, it's assigned a law number and published as a slip law, just a single print of the law. These slip laws are then compiled chronologically into bound volumes called the United States Statutes at Large. These are known as session laws.
Okay.
Then, public laws are incorporated into the United States Code, which is arranged by subject matter and updated annually with amendments showing the current status of the law.
Got it. Statutory law. What about federal administrative regulations? That sounds like bureaucracy.
Well, it can be complex. Congress often grants broad rulemaking authority to federal agencies,
Why do they do that?
often because Congress is, frankly, too gridlocked or slow to draft detailed statutes for every possible situation. Or sometimes they believe the agency's technical specialists are just better equipped to deal with specific, complex scenarios as they arise.
So they delegate the details.
Pretty much.
Yeah.
The process for regulations involves them first being proposed and published in the Federal Register. That's like the government's daily newspaper for rules. Then they're subject to a public comment period. People can weigh in.
Okay.
After considering comments, a final version is published in the Federal Register and then codified into the Code of Federal Regulations, or CFR, which is published once a year on a rolling schedule.
So Federal Register for Proposals, Code of Federal Regulations for the final rule.
Exactly. And an important distinction here is that how much power these regulations carry has actually shifted recently. Historically, under something called Chevron deference, courts gave them a lot of weight, almost treating them like laws themselves. But now, after a recent Supreme Court decision, they're subject only to a lesser standard, Skidmore deference. This basically means courts can challenge these agency rules more readily, potentially changing how influential they are in practice.
Interesting. So agency power might be weakening a bit?
Potentially, or at least subject to more judicial scrutiny. It's also worth noting the vast amount of non-binding agency documents out there, forms, manuals, policy statements, which can be persuasive, but aren't legally binding law.
Right. Okay, so the scope of federal law itself has expanded dramatically over time, hasn't it?
Oh, massively.
Traditionally, maybe 18th, 19th centuries, it focused on areas where the federal government had an express grant of power in the Constitution, like the military, money, foreign relations, intellectual property patents and copyrights, and the mail.
Right. Core federal functions.
But since the beginning of the 20th century, broad interpretations of the commerce and spending clauses of the Constitution have allowed federal law to expand into all sorts of areas, like aviation, telecommunications, antitrust, trademarks.
That's true. The nuances of this expansion are quite interesting, though. It's not uniform. In some areas, like aviation and railroads, federal law creates such a comprehensive scheme that it virtually preempts or pushes out almost all state law.
Okay, federal control.
But in others, like family law, you have a relatively small number of federal statutes, generally covering interstate and international situations, interacting with a much larger body of state law.
A mix.
Yeah. Then, in areas like antitrust or trademark, powerful laws exist at both federal and state levels, kind of coexisting.
Okay.
And in a handful of unique areas like insurance, Congress has even enacted laws expressly stating they won't regulate as long as states are doing the job, like the McCarran-Ferguson Act.
Fascinating. So it really depends on the subject area.
It really does.
We've explored federal statutes and administrative rules, but what about that judge-made law we mentioned earlier with stare decisis? Does that exist at the federal level in the same way it does for the states?
Federal common law. That's a great question, and it's a bit of a surprising story. Yes. Unlike the states, there isn't a federal law that just sort of continued English common law wholesale. There's no federal reception statute.
Yeah.
However, it's universally accepted that the Founding Fathers, by vesting judicial power into the federal courts in the Constitution, thereby vested in them the implied judicial power of common law courts to formulate persuasive precedent. They can write opinions that others might follow.
Persuasive, but not necessarily binding.
Well, that's the difficult question. Does federal judicial power extend to formulating binding precedent through strict adherence to stare decisis? Federal Judge Alex Kaczynski, in an interesting analysis, pointed out that binding precedent as we know it today simply didn't exist when the Constitution was framed.
Really?
Yeah. Judicial decisions weren't consistently reported back then, and the UK lacked a coherent court hierarchy. 18th century English judges saw themselves as merely declaring existing law, not making new law.
So the modern idea came later.
Exactly. This system of binding precedent, gradually developed in the U.S. during the 19th century, really is a matter of judicial administration and public policy. It was driven by establishing a clear court hierarchy, trial courts, appellate court, Supreme Court, and the regular publication of appellate decisions.
So people could actually read and follow them.
Precisely. Its justifications today include fundamental fairness, efficiency, stability, and predictability. It prevents every minor legal issue from being argued from scratch every single time. As Justice Breyer noted in a 2008 case, John R. Sanding Gravel Company v. United States, in most matters, it is more important that the applicable rule of law be settled than that it be settled right.
Wow. Better settled than settled right. That quote really crystallizes the practical philosophy behind binding precedent, doesn't it? Even if it might mean sacrificing a perfect outcome for stability.
It does. It emphasizes predictability.
However, there's a critical perspective on this, right? Over time, a line of precedents can kind of drift from the express language of the underlying texts, potentially creating doctrines not considered by the original drafters. This trend has apparently been particularly evident in federal substantive due process and commerce clause decisions.
That's a significant critique, yes.
And originalists and political conservatives, like the late Justice Antonin Scalia, have criticized this trend as anti-democratic, arguing it moves too far from the founders' intent.
That's a major ongoing debate in constitutional law. And related to this idea of federal common law is a landmark case, Erie Railroad Company Tompkins from 1938.
Erie. Okay, what's the takeaway there?
A major implication is that there is no general federal common law.
No general federal common law.
Right. While federal courts can create federal common law in the form of case law, that judge-made law must be linked, one way or another, to the interpretation of a specific federal constitutional provision, statute, or regulation. Federal courts lack the broad power that state courts possess to simply make up law, where no constitutional or statutory provisions exist to replace the common law.
So they can't just invent rules.
Not generally. Only in a few narrow, limited areas like maritime law, where the Constitution expressly authorized the continuation of judge-made law at the federal level, do you see something like true federal common law.
Okay, so Erie limits federal courts' power to create common law. What else?
The second major implication is that federal courts cannot dictate the content of state law when there is no federal issue at play.
Ah, back to that federal-state divide.
Exactly. This means that when federal trial courts hear claims under state law, for example, under what's called diversity jurisdiction, when people from different states sue each other in federal court, they must apply the statutory and decisional law of the state in which they sit.
They have to act like a state court in that situation.
Precisely, just as if they were a court of that state. And this holds true even if the federal judge personally believes the state law is irrational or represents bad public policy. They have to follow it.
Wow. That's a strong rule.
It is. And it's a reciprocal relationship, importantly. Under Erie, federal deference to state law applies only in one direction.
Meaning?
Meaning state courts are not bound by federal interpretations of state law.
Yeah.
If a federal court makes a ruling on what it thinks state law means, the state's own Supreme Court can say, no, that's not right.
Okay, states get the final say on state law.
Correct. Similarly, in the vast majority of state courts, interpretations of federal law from federal courts of appeals and district courts can be cited as persuasive authority, maybe helpful.
Yeah.
But state courts are not bound by those interpretations.
Only by the U.S. Supreme Court.
Exactly. The U.S. Supreme Court has never squarely addressed this specific issue, but has signaled that it agrees with this rule. Therefore, in most states, there is only one federal court that binds all state courts as to the interpretation of federal law and the federal Constitution, the U.S. Supreme Court itself.
That clarifies the hierarchy quite a bit.
Okay.
Now let's shift fully to state and territory law. You mentioned the 50 American states are truly separate sovereigns. Each has its own state constitution, state government, and state courts.
Right.
All states have a legislative branch that enacts statutes, an executive branch that issues regulations, and a judicial branch that applies, interprets, and occasionally overturns both state statutes and regulations as well as local ordinances. They retain that broad plenary power to make laws covering anything not preempted by federal law, the Constitution, federal statutes, or international treaties.
Correct. And normally, state Supreme Courts are the final interpreters of their own state constitutions and state law, unless, as we said, a federal issue gets involved, then the U.S. Supreme Court might step in.
Okay. And the key thing here seems to be the sheer variety.
Absolutely. What's fascinating and really crucial to understand is the dramatic divergence of state laws that has occurred over centuries since independence. To the extent that the United States cannot be regarded as one legal system for the majority of types of law traditionally under state control, things like tort, family, property, contract, criminal law, it must truly be regarded as 50 separate legal systems.
50 different systems running in parallel.
Pretty much.
Yeah.
The sheer volume of cases litigated in state courts is immense compared to federal courts. In 2018, state trial courts received 83.8 million newly filed cases. That included 44.4 million traffic cases, 17 million criminal cases, 16.4 million civil cases.
83.8 million.
Yeah. Compare that to, say, about 274,552 new federal civil cases in 2016. It's a huge difference. It truly illustrates that for most Americans, their interaction with the law happens far more often at the local and state level than with big federal cases.
That makes a lot of sense. And we should also mention the U.S. territories, right? Places like Puerto Rico, Guam.
Yes, absolutely. They have their own specific legal systems, too, often a blend of civil and common law traditions, like American Samoa, Guam, the Northern Mariana Islands, Puerto Rico, and the U.S. Virgin Islands. Each is unique.
Okay. And finally, we come to the most granular level, local law.
Right. Below the state level, states have delegated lawmaking powers to literally thousands of agencies, townships, counties, cities, and special districts like school districts or water districts.
Thousands, wow.
Yeah, the result is that the average American citizen is subject to the rules and regulations of several dozen different agencies at any given time, depending on where you are and what you're doing.
Several dozen. It sounds complicated.
It is. It's a truly intricate web, almost like needing a legal GPS just to navigate your daily life sometimes.
That's a great way to put it. A legal GPS. Okay, we've peeled back the layers.
Yeah.
Federal, state, and local. Now, let's try to put it into practice and explore how these different levels shape the legal subjects that impact you most directly. It might help to start with a fundamental distinction American lawyers make between procedural law and substantive law.
Good idea.
Procedural law basically controls the process how legal rights are enforced. Substantive law defines the actual rights and duties themselves. Does that sound right?
Perfect summary. Procedure is the how, substance is the what.
Okay, so let's start with a big one. Criminal law and procedure.
All right.
Criminal law involves the state prosecuting wrongful acts, considered so serious they breach the sovereign's peace, as the old phrase goes. And generally, crimes can result in incarceration, unlike civil wrongs or torts, which usually involve money damages.
That's a key distinction, yeah.
Yeah.
Loss of liberty.
And the majority of crimes committed in the United States are prosecuted at the state level.
Overwhelmingly so. Federal criminal law focuses on areas specifically relevant to the federal government. Things like tax evasion, mail theft, physical attacks on federal officials, counterfeiting, and also interstate crimes like drug trafficking, kidnapping across state lines, wire fraud.
Okay. And even for similar crimes, the laws vary state to state.
Definitely. While higher crimes like murder and rape have, somewhat similar definitions across states, the penalties can vary significantly. Think about capital punishment permitted in some states, not others. Or three strikes laws that mandate harsher sentences for repeat offenders, which exist in some states but not all.
Right.
And states generally distinguish between felonies, more serious crimes, usually resulting in lengthy prison sentences, probation, big fines, and misdemeanors, less serious, typically leading to a year or less in local jail, or maybe just a substantial fine.
Felonies and misdemeanors.
Yeah. Some states even add a third, lower level, often called infractions or violations, for minor offenses like traffic tickets, which usually only result in fines or maybe losing your license, but no jail time.
Got it. Here's a surprising fact I came across. On average, only about 3% of criminal cases are actually resolved by a jury trial.
That's right. It's remarkably low.
A stunning 97% are terminated either by plea bargaining, where the defendant agrees to plead guilty, often to lesser charges, or by dismissal of the charges altogether.
The system relies heavily on plea bargains to function, for better or worse.
And there's also significant diversity across states for what are called public welfare offenses, like drunk driving or drug possession, where the specific laws and punishments can vary quite widely.
Huge variations there, yes.
Yeah.
Now, turning to criminal procedure, the how part. The law of criminal procedure in the United States is, well, it's a massive overlay of federal constitutional case law, primarily from the Supreme Court interpreting the Bill of Rights, interwoven with various federal and state statutes that also regulate the process.
So the Constitution plays a big role in how criminal cases are handled.
A huge role, because legislatures in the U.S. have, historically, consistently struggled to pass laws that effectively force law enforcement to respect the constitutional rights of criminal suspects. The federal judiciary gradually developed what's called the exclusionary rule.
The exclusionary rule, that's about evidence.
Exactly. It prevents illegally obtained evidence seized in violation of the Fourth Amendment, for example, from being used against the defendant in court. And in turn, this rule spawned a family of judge-made remedies, the most famous of which is probably the Miranda warning.
You have the right to remain silent. Everyone knows that one from TV.
Right. That warning stems from court decisions designed to protect the Fifth Amendment right against self-incrimination during police custody. We should also mention the writ of habeas corpus, a very old legal action that allows a person to challenge the legality of their detention or imprisonment. It's a crucial safeguard.
Habeas corpus. Okay.
And there are other mechanisms, too, like civil rights lawsuits under federal law, sometimes called Bivens actions or Section 1983 actions, which can be used to sue government officials, including police, for constitutional violations like excessive force.
Okay, so a complex mix of constitutional rights, court rulings, and statutes governing criminal procedure.
Very complex, yes.
Let's move on to civil procedure then. This governs lawsuits between private parties, right? Not the state versus an individual.
Correct. Person versus person, company versus company, or person versus company.
Historically, the source mentioned common law pleading was very rigid, then replaced by code pleading in many states, starting with New York's Field Code in 1850, which then largely evolved into modern notice pleading. What's the difference there?
Well, common law pleading was incredibly formalistic. You had to pick the exact right writ or form of action, and if you picked wrong, your case was thrown out, regardless of the merits. Very rigid. Code pleading tried to simplify that by focusing more on stating the facts constituting a cause of action. Still somewhat formal, but better. Modern notice pleading, used in federal courts and many states now, is much more flexible. You essentially just need to give the other side fair notice of what your claim is about and the basic grounds for it. Less focus on technicalities, more on substance.
Makes sense. More practical.
Yeah. And the Old English division between courts of law and courts of equity, which handled different types of remedies like injunctions, was largely abolished in the federal courts by the Federal Rules of Civil Procedure in 1938.
Law and equity merged.
Pretty much, yeah. Most states did the same thing through legislation. Though, interestingly, the Delaware Court of Chancery is a famous example of a court that still primarily handles equity cases, especially complex corporate disputes.
Delaware's Special Corporate Court.
Right. Now, the influence of those Federal Rules of Civil Procedure, the FRCP, has been huge. Around 35 states have adopted rules of civil procedure modeled directly after the FRCP, often even using the same rule numbers.
So federal rules shaped state rules.
In many cases, yes. But they had to make some modifications, mainly because state courts usually have broad general jurisdiction. They can hear almost any type of case, while federal courts have limited jurisdiction, restricted to specific types of cases outlined in the Constitution and federal statutes.
Gotcha. And not all states adopted them.
Right. New York, Illinois, and California are notable non-adopters. They still mostly rely on codified statutes for their civil procedure, although even they have tweaked parts of their laws over time to align somewhat with federal practice.
Okay. Now, American civil procedure itself has some pretty distinct features compared to other countries, doesn't it?
Oh, definitely. Several stand out.
Like extensive pretrial discovery.
Yes, absolutely. The process where parties can demand information and documents from each other before trial is far more extensive in the U.S. than in most other legal systems. Depositions, interrogatories, requests for documents, it can be a huge part of the case.
And a heavy reliance on live testimony.
Right. Either at those pretrial depositions or, crucially, elicited live in front of a jury at trial. There's a strong preference for seeing and hearing witnesses directly.
Okay. And aggressive pretrial motions.
Yeah, what's often called law and motion practice. Lawyers spend a lot of time filing motions before trial, trying to get claims dismissed, or get summary judgment or ruling from the judge that avoids a full trial, or simply push the other side towards a settlement.
So a lot happens before you even get to a trial.
A huge amount. And speaking of unique features, U.S. courts pioneered the opt-out class action.
The class action lawsuit. Explain the opt-out part.
Okay, so in a class action, one or a few people sue on behalf of a much larger group or class of people with similar claims. In an opt-out system, which is dominant in the U.S., everyone who fits the class definition is automatically included in the lawsuit unless they take active steps to notify the court that they want to be excluded or opt out.
So you're in unless you say you're out.
Exactly. This has been described as the most extreme development of collective civil litigation globally. In many other countries, you typically have to actively opt in to join a class action.
That's a big difference in philosophy.
It really is. Another unique feature, though maybe less so now with some reforms, is the American rule regarding attorney's fees.
The American rule.
Yeah, that's the default principle that generally each party in a lawsuit pays their own lawyer's fees, regardless of who wins or loses.
Unlike the loser pays system in some other countries.
Right, often called the English rule. Now, it's important to stress that numerous exceptions to the American rule have been created by statutes like civil rights laws, often allow prevailing plaintiffs to recover fees, and sometimes by contract. But the default is still that each side bears its own costs.
Interesting. Okay, let's shift gears to contract law.
Sure.
This covers obligations established by agreement, right, whether express or implied, between private parties.
That's the core of it, yes. Promises the law will enforce.
And is this mostly state law?
Predominantly state law, yes. However, contract law for one specific very important area, the sale of goods, has become highly standardized nationwide.
Sale of goods, how so?
Through the widespread adoption by nearly all states of Article 2 of the Uniform Commercial Code, or UCC.
Ah, the UCC. Heard of that.
Yeah, it provides a common set of rules for things like forming sales contracts, warranties, delivery, remedies if something goes wrong. So buying and selling goods is legally pretty similar across state lines.
But for other types of contracts, services, real estate, employment.
For those, you see significant diversity remaining in the interpretation and enforcement. It depends on the extent to which a state has codified its common law of contracts into statutes, or how much weight its courts give to advisory legal texts like the American Law Institute's restatement, back end of contracts.
Restatements.
Yeah.
Those are like summaries of common law rules.
Exactly.
Mm.
They try to distill the majority rules from court decisions across the country, but states aren't required to follow them. They're just persuasive.
Okay. And parties can agree to skip court altogether.
Yes. Importantly, parties are generally permitted to agree in their contract to arbitrate any disputes that might arise instead of going to court.
Arbitration.
Right. And under the Federal Arbitration Act, these arbitration clauses are generally enforceable unless the party challenging it can show something like fraud or unconscionability or some other ground that would invalidate the entire contract itself. Arbitration has become very common.
Got it. Now let's tackle tort law. This sounds broad.
It is very broad. Tort law covers civil actions between private parties that arise from wrongful acts. But these are breaches of general obligations imposed by law, not specifically by a contract between the parties.
Okay. Duties we owe each other generally.
Exactly. Like the duty not to be negligent and cause injury, the duty not to trespass on someone's property, the duty not to defame someone.
So it involves interference with a person, property, reputation, or commercial or social advantage, as the source puts it.
That's a good summary. And it can even overlap with criminal law, like assault and battery can be both a crime and a tort.
And this is mostly state law, too.
Overwhelmingly state law, yes. Developed mostly through state appellate court case law, those judge-made precedents we talked about. It's very rarely a matter of federal law.
And you mentioned restatements again. Did they try to standardize tort law?
They did. The American Law Institute has published several restatements of torts, trying to summarize and clarify the rules. But many states chose to adopt only certain sections or rules from the restatements, while rejecting others or sticking with their own unique precedents.
Lots of variety again.
Immense diversity. For example, a few jurisdictions allow lawsuits for negligent infliction of emotional distress, even if the plaintiff didn't suffer any physical injury. But most states do not allow such claims without some physical impact or consequence.
Wow.
And for practically any tort you can name, negligence, defamation, trespass, products liability, you'll find a majority rule adhered to by most states, and then one or more minority rules followed by other states regarding the elements of the claim, the available remedies, and the statutes of limitations, the time limits for filing suit.
So this dramatic divergence means if you're ever in an accident or dealing with, say, a property dispute that involves a tort, the legal outcome could be vastly different depending on which state you happen to be in.
Absolutely critical to understand that. State lines really matter in tort law.
Now, the source highlighted one specific area as the most broadly influential innovation of 20th century American tort law, the rule of strict liability for defective products.
Yes, that was a game changer.
It originated from judicial interpretations of warranty law. How did that work?
Well, traditionally, if you were injured by a defective product, you often had to prove the manufacturer was negligent, which could be difficult. Warranty law offered another route, but it often required privity, meaning you had to have bought the product directly from the manufacturer, which often wasn't the case. Then, in 1963, Justice Roger J. Traynor of the Supreme Court of California issued a landmark decision in Green Man v. Yuba Power Products. He basically said that manufacturers should be held strictly liable, meaning liable without needing to prove negligence if their defective products cause injury. He framed it as a matter of public policy to ensure costs of injuries are borne by manufacturers who put products into the market.
Strict liability. So just showing the product was defective and caused harm is enough.
Essentially, yes. It dramatically lowered the burden for injured consumers. The American Law Institute then quickly adopted a slightly different but similar version of this rule in Section 402A of the Restatement Second of Torts, published just a year later in 1964.
And that restatement section was influential.
Incredibly influential. It was adopted by courts in almost every state, really cementing strict products liability across the U.S., and it even saw international adoption. The European Economic Community adopted a directive based on it in 1985, Australia followed in 1992, and even Japan in 1994.
Wow, a U.S. tort law concept went global.
It did, but the sheer volume, the avalanche of American cases that resulted from Greenman and Section 402A created so much complexity and variation in the details that a further restatement was eventually needed. This led to the 1997 publication of the Restatement Third of Torts, Products Liability, which tried to refine and clarify the rules based on decades of case law.
It's a clear example of how judge-made law can evolve and have a profound, even global impact.
Absolutely.
Okay, next up, property law. Historically, American property law was heavily influenced by English land law.
Very heavily,
Yeah.
especially regarding real property, land, and buildings. The focus was initially on that, and secondarily on personal property movable things.
And primarily state law again?
Yes, almost entirely state law.
Is there as much variation here as in torts?
Even more so, arguably. The source notes that the level of interstate diversity in property law is much more substantial than in contract and tort, and efforts by both the American Law Institute, with its restatements of property, and the Uniform Law Commission, which drafts model statutes for states to adopt. Their efforts to reduce this diversity in property law were, quote, spectacular failures. States really guarded their own unique property rules.
Spectacular failure, so property law is very state-specific.
Extremely. For instance, how real property ownership is recorded and verified differs. Most states use a title recording system where deeds and mortgages are filed in a county office. Proving ownership often relies on searching these records and getting private title insurance.
Okay, recording systems.
But a small minority of states use, or allow use of, something called Torrens title registration. It's a system where the government itself examines and certifies the title, issuing a conclusive certificate. Supposedly simpler and more secure, but it never really caught on widely in the U.S.
Interesting. And what about personal property? Cars, furniture, etc.?
Usually personal property ownership isn't formally registered. You just possess it or maybe have a bill of sale. There are notable exceptions, of course. Motor vehicles require state registration and titles. Some states might register bicycles. And certain types of firearms are subject to registration requirements under federal and/or state law. But mostly, personal property is less formally tracked.
Got it. Last major subject area, family law.
Okay.
In the United States, family law governs relationships between adults, marriage, divorce, domestic partnerships, and also between parents and children, custody, support, adoption.
Right, the core family relationships.
And the source says that as a distinct area with its own specialists, American family law is relatively young compared to European family law.
That's generally true. It really took flight and became a major specialized field with the no-fault divorce revolution that swept across the states starting in the late 1960s and 1970s.
No-fault divorce. How did that change things?
Well, before the 1950s and 60s, divorce was much harder to get. Widespread religious, legal, and social prohibitions made divorces rarer. When they did happen, you usually had to prove specific grounds like adultery or cruelty. They were often seen as very fact-driven, unpleasant cases, focusing on who was at fault, and they rarely went up on appeal.
Okay, fault-based.
Right. The rise of no-fault divorce, where couples could dissolve a marriage based simply on irreconcilable differences or irretrievable breakdown, shifted the focus of the litigation. It moved away from the often messy question of who was to blame for the marriage ending and instead concentrated on the practical issues. How to divide property, whether spousal support, alimony was appropriate, and crucially, arrangements for child custody and child support.
So it professionalized the field, in a way.
Definitely. It created complex financial and custodial issues that required specialized legal expertise.
And traditionally, family cases are state law matters, almost always heard only in state courts.
Yes, that's a very strong tradition. Federal courts generally decline to hear family law cases under a long-standing judge-made rule called the domestic relations exception to their diversity jurisdiction.
Domestic relations exception. So even if the divorcing couple lives in different states, they usually can't sue for divorce in federal court.
Correct. The idea is that family law is inherently local, best handled by state courts that are more familiar with state laws and local circumstances.
But is there any federal involvement?
Yes. Despite family cases being primarily state level, there's been a definite trend towards the federalization of certain specific issues within family law.
How so?
Well, state courts and the lawyers practicing before them absolutely must be aware of federal income tax and bankruptcy implications when structuring divorce settlements and judgments. Those are federal laws.
Money issues.
Right. Also, federal constitutional rights come into play. Think about landmark Supreme Court cases related to marriage, abortion rights, paternity rights. State family law have to comply with those federal constitutional standards. And Congress has passed federal statutes that govern interstate child custody disputes, like the Uniform Child Custody Jurisdiction and Enforcement Act, UCCJEA, which states have adopted to coordinate, and also federal laws to help enforce child support orders across state lines.
So federal law steps in mainly for the interstate or constitutional aspects.
That's a good way to summarize it.
Yeah.
The core divorce, custody support decisions are state law, but federal law creates an important overlay in specific areas.
What a journey. We've really covered a lot of ground here. We've recapped our deep dive from the foundational Constitution, explored the many layers of federal, state, and local law, and then delved into these varied subjects like criminal law, civil procedure, contracts, torts, property, and family law. It truly highlights the incredible complexity, the surprising variations between states, and the constant evolution that defines American law.
It really does. And this understanding, hopefully, is key to making sense of the living law that you actually experience every day. By understanding these multiple layers and the unique divergences, sometimes stark divergences, you can hopefully see the threads that connect and sometimes intentionally disconnect the legal fabric of the nation.
Yeah.
It's about appreciating the immense, intricate system, or maybe systems, plural, that governs so much of life in the United States.
Definitely systems, plural.
Yeah.
So thinking about all this, given the immense and, as you said, often intentional divergence of state laws, especially in areas like tort, family, and property law, how do you think this decentralized legal landscape impacts individual experiences when people move between states? I mean, your rights and obligations can change significantly just by crossing a border. And what does it suggest about the ongoing balance, that tension, between national unity and local autonomy in the very foundation of American life? Something to think about.